Every day, SDPB connects South Dakotans with stories that inform, inspire, and bring us together. SDPB, good, useful, and full of wonder. SDPB is your home for fact-based journalism, connecting South Dakotans with news they can trust and stories that matter. Good, useful, and full of wonder. SDPB.
If you plan to testify, please sign in on sdlegislature.gov. Press the people icon on the agenda on the homepage and fill out the form, or you can do this directly on your phone by scanning the QR code in the agenda. So with that, I'll ask the secretary to please call the roll.
Senator Blanc.
Here.
Duhamel.
Here.
Grove.
Here.
Melhoff.
Here.
Pischke. Hulse excused. Kolbeck.
Here.
Mr. Chairman, we have a quorum.
Thank you. And just so we all know, we do have a room reserved for this afternoon. We're going to get through our calendar. Whatever we don't complete will be heard Tuesday after the Senate floor adjourns. So I anticipate that we'll get down to HB 1183. That's my goal. HCR 6015 will for sure be heard this afternoon because Representative Mucky is in appropriations and cannot get out of budget setting. So that's kind of our tentative plan. With that, we do have some minutes out there. I'll take a motion to approve the minutes.
So moved. Second.
So moved Duhamel, second by Blanc. Comments on your motion? Hearing none, all in favor say aye. Aye. Opposed? Thank you. Just a reminder to testifiers to sign in to ensure your lobbyist badge is being worn. And then if you have any handouts, please distribute them through the pages. So with that, how about we get a little introduction from our page here? Tell us who you are, where you're going.
Hi, I'm Olivia Moffett. I am from Hot Springs, like Senator Hulse, but she's not here. And I plan on going to business school through Southern New Hampshire University and going to law school in Florida. I'm not completely sure of where yet.
Wow, awesome. All right, with that, we'll get our other page at a different time. Any personal privileges? Hearing none. Reminder to all testify, all that want to testify, all questions will be run through the chair. With that, we'll go to the top of our agenda. HB 1040, revise the child support obligation schedule. Representative Stevens. And just so everyone knows, we're going to keep a really, really tight 10 and 10 today. 10 minutes pro, 10 minutes con.
Thank you, Mr. Chairman and members of the Judiciary Commission. I was appointed to the Commission on Child Support. This commission is required by the federal government to meet every 4 years. The next review will not occur till 2029. So in other words, this schedule that we're looking at, again, will not change until 2030. And so this involves 43,000 cases across the state of South Dakota. So what do you decide today will be what the child support amounts will remain for the next 4 years with no changes. The last revision was in 2022, 4 years ago, and the next review will not occur till 2029. The child support figures in the schedule do not change automatically. There's no inflationary figures that are calculated into this so that it automatically changes each year. Each year it does not do that. So whatever you decide today will be the child support amounts that'll be in effect until July 1st of 2030, regardless of what happens with the economy. The Child Support Commission aims to establish a consistent standard of living for the children across both homes. When I started practicing law in 1978, every case was different, and it was not based upon any data. It was just based upon what the judge felt in the numbers. And so this made it consistent across the state of South Dakota. The adjustments to the schedules updates obligations based upon economic data which demonstrate the true cost of raising a child in South Dakota. The schedule is also informed by economic data that reflects the wages South Dakotans are earning. The most recent and South Dakota specific economic data was available, which are incorporated into these updates. This data was reviewed by the 2025 Support Commission over the course of 8 open meetings before adoption. And if you want to look at all the financial documents that we looked at, that's where they are. So what was considered in updating the schedule? The critical data that were examined creating the schedule includes price levels for costs of essential goods, expenses typically incurred in rearing children, cost of living in South Dakota, spending of after-tax income on children, exclusion of highly variable child rearing expenses such as child care and medical costs, and basic subsistence needs of the payer who has a limited ability to pay. So the updated schedule reflects an average increase of 3%, not 10%. There's some that are higher, there's some that are lower, but the average is 3%. So what are the changes that we are looking at here from the standpoint of economic data? Since July of 21 through March of 2025, prices have increased 15.6%. Food has gone up 21.7% and housing 19.7%. Cost of child rearing expenditure has increased, as we all know. Another major factor that was taken in consideration was the difference between South Dakota and U.S. family income. South Dakota's mean income was 92.2% of the U.S. mean income. One of the major factors that had also required to be taken in consideration is the current federal poverty guidelines. So the proposed schedule will update the figures approved in 2022. So in other words, no changes in the schedules have occurred in the last 4 years. So in 2022, even though inflation went up, there was no changes in the schedule. 2023, inflation went up, there was no changes in the schedule. 2023, there was no changes in the schedule. 2024, and it goes on. And so if there's going to be any changes, it won't occur till 2030. Now, so that's what makes this law difficult, because we look at it every 4 years as opposed to every maybe a couple of years. So instead of a nominal increase each year, you have these kind of different fluctuations. So if you have in front of you, you have a worksheet, and I will show you just very briefly what this involves when you look at this. So if you look at the worksheet, and I just made these numbers up, I just picked numbers. I didn't look at it to see what it might make it look like that I'm trying to get something passed. But if you have, this is the child support obligation calculator that's online. You plug in the numbers. So if you have the non-custodial parent earning $4,000 and the custodial making $3,000, non-custodial $4,000, and then you take out, because each person is allowed to take 10% of their retirement, you see where that is. And then they get down to the monthly net income, which is you see for each party, the net monthly income is $52.84. You take that figure and you go to the very next page, and you see that's where the current schedule is, and you can see the individuals who are in that part. The total amount of child support is $14.88. That figure does not apply, does not mean that's what the non-custodial parent pays. Because then you go down to the next part and you see the $14.88, but you see right above it is percentages. And the non-custodial parent pays the percentage of the figure that's on this second page of $14.88. So then you have, that comes down, well, the monthly child support obligation is $848. If the non-custodial parent is paying the insurance, then the custodial parent has to pay their percentage of that insurance, which is 43%, and that's where you see the minus $108. So in this particular situation, the amount of child support is $741. Now, how does that change on this new bill? When you go to the next page and you see now that amount has gone up to $1681, but the same things apply. It's a percentage of that less the percentage of the health insurance. And so when you come down to it, the difference between the two, if you look at the very last page, comparison of current and proposed child support, what happens is the difference is $108 a month. That's what it comes down to. Now, can they change that? If you look at the fourth page that I've given you, South Dakota law allows factors considered for deviation from schedules, and you look at number 2 specifically, and it says that when they appear before the judge or they appear before a referee, any financial condition of either party would make application of the schedule inequitable. That child support referee or the judge can make a modification in that. So with that brief thing, I know you're busy. That's the presentation I have for House Bill 1040. Thank you.
Thank you. Any other proponents in the room? We're at about 7 minutes here.
Thank you, Mr. Chair. My name is Matt Althoff, Cabinet Secretary, Department of Social Services. I, too, served, as did Representative Stevens, on the Child Support Commission appointed by Governor Roden. And I just want to emphasize that group is comprised of family law attorneys appointed by the bar. It's a judiciary member chair. People who referee, this is a group of people that live in this ecosystem all day long. And I say that because I think child support, we would all probably recognize, it can feel like a foreign language. It's a different space. And so these are people that live, breathe that year round. And we spent, as the good representative said, eight meetings, 4 hours each on our calendars for those meetings, and examine this. The reason schedules are updated periodically every 4 years is our custom is that underlying costs of raising a child isn't fixed. It increases. And we all know that, those of us who have children, it increases whether our income goes up or not. And so while, as the good representative has emphasized, this is a 4-year decision, look forward prospectively. When you choose not to, somebody bears the cost of that, and it typically is the receiver. These costs have gone up in the 4 years since this last schedule was set. The receiver has borne the cost of that. And so the obligation, remember, is factored based upon what's the purchasing power happening, what's the basket of goods that go into the business of child rearing. It's an intense examination of that through economic science. We look at some of the shifts that are going on in the business of child rearing. There's technology, certainly healthcare, as we see private insurance continue to do cost sharing. We look at child care costs that are borne by households that have children in their care. These are all major shifts going on in our economy that are a factor into what goes into that obligation calculation that needs to be updated not only this year, but for the upcoming 4 years. Again, our goal, the legal philosophy that has established our framework that's in place here for many, many generations in South Dakota now is that each child the philosophy is that each child should receive the same proportion of parental income that would have received if their parents lived together. That's the framework that we look at. And so we ask you just be mindful of that, is that we're doing our best with this schedule to make certain that the child's standard of living is on a par as if those two parents were together. That's why the obligation needs to be updated, is the cost to rear that child increase year over year. So I would just respectfully ask this commission, this committee's strong endorsement of this, given, number one, the amount of effort that went into it, the economic science that informs this schedule, and most especially the fact that this is a reality of, to raise a child today, it is more expensive. And even though our incomes do not always increase proportional to the cost of child rearing, the obligation ought to, so that that child has a sense of the proportional amount of benefit from the two households, even if they are separated. So thank you very much for hearing our testimony today. We'll stand by for questions.
Thank you. And with that, we are right at 10. So if there are any Me Too's, we'll take them in-house. Anyone online? If not, literally 10 minutes and 10 seconds. So we'll go to opposition. Any opponents? HB 1040.
Good morning, Mr. Chair and members of the committee. Senator Tom Pischke. Usually in these I would just sit over here and just have my say over here, but I want to provide some opposition testimony here. You know, while it may seem that the intent of these increases to ensure children have adequate financial support is commendable, we must carefully examine the consequences of such policies can have on families, parents, and children alike. First, we must recognize the financial strain on non-custodial parents. Increasing child support obligation often means requiring parents to pay beyond their means. Many non-custodial parents are already managing limited incomes, struggling to meet rent, transportation costs, and other essential expenses. By imposing these higher payments, we risk pushing them into financial hardship, late payments, or even default, which ironically can result in less child support that we seek to protect. Second, higher obligations can create tension and conflict between parents, which is counterproductive to a child's well-being. Families work best when co-parenting relationships are cooperative, not adversarial. Forcing unenforceable payments can lead to legal disputes, resentment, strained communication, all of which ultimately affects the child. Third, we must consider the unintended consequences on children. When a non-custodial parent cannot meet steep obligations, they may disengage from parenting altogether. Studies show that children benefit not only from financial support, but from active involvement by both parents. Excessive financial demands risk reducing that involvement, which can have long-term emotional and developmental impacts. Finally, increasing child support while considering the broader economic realities such as wage stagnation, cost of living, and inflation fail to achieve the intended goal of improving child's life. A fair, balanced approach ensures that children are supported without pushing parents into unsustainable financial situations. And while we all can agree that that children deserve child support, we must ask ourselves, is increasing obligations truly helping them? Or is it just creating further challenges for the families we aim to assist? Responsible child support policy should balance the needs of children with the realistic abilities of parents. Pushing for increases without the balance risks harms to the financial stability of parents and ultimately the well-being of children themselves. I want you to take a look at some of the handouts I gave you here. I know we have very limited time, but I also gave the child support calculator and gave a situation, looked up the average wage of someone in South Dakota. The average salary of someone in South Dakota is about $55,943. That's what I put into the calculator. And if you look on the one that says page 5 and page 23 on it, that's what I'm going off of here. So in that situation, the total support obligation is $1,717. With this bill, that's going to go to $1,861. The monthly child support obligation is $859, and I don't have then it's going to go to $930 after that. So that's really the impact of what's happening here. After that, I want you to put your attention to this sheet right here. This just covers like your basic expenses. After all is said and done, taxes are taken out, your take home with that situation is $1,635.71 a month. If you have child support taken out bi-monthly, that's $465. The average rent in South Dakota, I looked this up, is actually closer to $1,400, but I said we found a 3-bedroom apartment for 2 children at $1,200 a month. I think that's very reasonable. If you have a vehicle payment, I put at $300 a month. Your cell phone, monthly groceries, monthly gasoline, your water bill, your student loan, electric bill, internet bill, student loans. These are all just your basic necessities. And if you look at the numbers, you're in the red. You're going backwards every month with what we're doing here. So I think that we just need to give some consideration to what's actually going to happen to the payer in these situations. So I'll stand by for questions, but I just ask you to think about what you're doing and think about the impact that this has on the payer, because both parents have to survive in these situations. Thank you, Mr. Chair.
Thank you. Any other opponents? Any other opponents in the room? If not, we'll give a brief rebuttal. There's no one online.
Thank you. Well, I would just say this, that everything that's in the schedules are based upon economic data, and you can always pick out one situation that may look a little different, but the same economic factors and expenses that the payer has are more so for the person who's the custodial parent, who has the kids all of the time. And when you look at the last page that I gave you on mine, we're always talking about the payer, but when you look at it, we're the custodial parent's responsibility, they have to pay all of those expenses as well. So when their expenses go up, so everybody's expenses go up. So it's not just the payer. What we're looking at here is what does it cost to raise a child? Instead of the emphasis being on the custodial parent or on the non-custodial parent, is we're trying to equalize what it is when those kids go from one place to another. And in this situation here, if this isn't passed, that means that going all the way back to 2022 to 2030, there will be absolutely no changes in that schedule. And that's not right. And we know those prices have gone up, and the inflation, the amount of inflation that's gone up cuts away all the time. And so it's only fair that in this situation here that we update that for the kids' best interest. Thank you.
Thank you. With that, we'll close public testimony and move to committee questions.
Mr. Chair,
Yes.
whatever information he has been referring to, I, for one, did not receive it.
Oh.
So I don't have any of the numbers that he's talking about. I've only received it from the senator.
Just hand it out.
This is actual.
There's
Thank you. Okay.
Sorry, I stuck it right here.
No, that's okay.
I don't know what you think. You got one now?
I think this is it.
Yes, ma'am.
Okay, thank you. Okay, sorry, thank you.
No worries. All right, any questions from committee?
Mr. Chair?
Yes, Senator Pischke.
I'd like to ask a question to Representative Stevens. Representative, in your packet here that you handed out, you highlighted number 2, any financial condition of either parent that would make application of the schedule inequitable. Sorry. So you're saying here that the child support referee can basically deviate from whatever is in the schedule to do whatever number they want if they deem it to be inequitable. Is that correct?
That's what the law says, yes.
Follow up? In your professional opinion, how often do they actually do that?
Well, I hate to use the word, it depends. That's one of the things that I think is very important for us to look at. There are 6 of these type of things that you look at, and I think the referees have a really difficult job, as you know, in dealing with this. And so to say, well, what factors specifically come into play, I think that's why you have these people who've done it for a long time, and they take into consideration of what's all being involved. And so when you look at these different things, even the effective agreement between parties, extra forms of support for the direct benefit of the child, there are a lot of factors that come in. And so to be able to enumerate and list every one of them that they could take in consideration, I think that's why it's broadly written in that regard.
Follow up, Mr. Chair. What would a parent have to show to the child support referee to make that application that the schedule is inequitable?
Well, first of all, there's actually two ways to deal with this schedule. Number one, if a person's income, either party's income deviates or goes down, okay, you can file a petition for modification, which then can recalculate whatever that might be. And if any one of these deviations come into play, that's a second way that the child support referees can make that deviation. So maybe there's a situation where there's an illness or an extended illness or something along those kind of lines, then one could do that, any one of these that fit in the situation here.
All right. We're going to acknowledge there's history here, so we're going to move on to any other questions. Any other committee questions? If not, we'll move to action. Any action?
Mr. Chair,
Yes.
wait, are we having comment?
Yes.
I just want to point out, I have been a recipient of child support payments, and I want to say a couple things. First of all, I have an issue with the state of South Dakota waiting 4 years to reconsider child support payments. That's not the conversation fully, but it is a part of the problem that I have with this bill. Second of all, as a mother who received child support payments, what was just mentioned was modification. And so there wasn't a lot of conversation about that when we talk about it's been 2022 and then it'll be 2030. The fact of the matter is in the state of South Dakota, we have an amazing system that allows for a parent who is the custodial parent to go back and modify child support. So if the other parent has gotten a promotion and they're rocking and rolling, the other parent can modify the child support. It used to be every 2 years. It appears now that it's every 3 years. But you can modify if you can show that there's been an increase. And it used to cost like $25. And so if you're a parent who's struggling and you have all the kids and you're doing all this stuff, you literally, it's like $25. It's incredible that we offer that as a state. And if you can prove that you are, doing really poorly and you're struggling as a parent, the state won't even charge you the $25. So I just wanted to make that super clear that you can modify child support. It's not from 2022 to 2030 with no increase. You literally can modify it when you can prove that there's been a change in income. I just wanted to say that. Thank you.
Any other discussion?
Mr. Chair? Okay, I'd like to discuss a few things. I know you want to move on, and I understand that, but this is a really important issue to me.
Absolutely.
And so, in the scenario and the obligation calculator that the goods representative handed out, even in that situation, that's the non-custodial parent making $48,000 a year. And in that situation that he laid out, that's going to increase the child support obligation from $741 to $850 a month. Keep in mind that all these expenses that I laid out here for rent and groceries and your bills are still your reality. These are very modest numbers. I mean, I looked up all the South Dakota averages on all these things, and these are on the low end of them. And so this is someone living very modestly. It doesn't take into account vehicle insurance. It doesn't take into account vehicle repairs. It doesn't take into account any miscellaneous things that are going to come up in life. And you're still going backwards every month. And I can tell you firsthand, this was my reality. This was my life for many years. And in fact, if I hadn't remarried, I would still be going backwards. Just based on, I have 3 children, and the amount of income that I make and my ex-spouse makes, it would push me farther and farther into the hole. And so I understand that it feels good to vote for more money for the kids. I totally understand that. And I want to support my kids too, but you cannot continue to push people down and down and down because they're in this child support system. So I just really would ask you that you consider voting no, just because, we can't push people down farther financially. So, thank you, Mr. Chair.
Good comments. Any other discussion? If not, I'm going to look for action.
Mr. Chair,
Senator Melhoff.
I would move do pass.
I have a motion from Senator Melhoff, second from Senator Duhamel. Do pass. Comments on your motion?
Thank you, Mr. Chair. When I took this job, I was told there would be no math, but apparently that was not true. And this is a very complicated process to determine this. And there are referees that are involved, and I certainly understand. And I've been somewhat involved with this child support, and I understand how the emotions and the struggles of trying to maintain two households and custody of kids, but at the end of the day, you have to provide for the children, and you have to make adjustments to reflect inflation and the economy and how things go. So I would just recommend a yes on the motion.
Any other comments on the motion? If not, we'll have the secretary call the roll, please.
Senator Blanc,
Pass.
Duhamel,
Aye.
Grove,
No.
Melhoff,
Aye.
Pischke,
No.
Hulse, excused. Colbeck,
Aye.
oops, sorry, Mr. Chairman. Senator Blanc.
No.
Mr. Chairman, we have 3 ayes and 3 nays.
All right, we'll hold that until Senator Hulse gets back. Yep, all right, we're going to move on to House Bill 1045. Revise certain provisions related to child support. Representative Stevens.
Thank you. House Bill 1045 also came from the Child Support Commission, and this is basically the recommendations that are made by the child support referees. It's really very simple type of things. For example, setting the presumption of the number of hours a person can work, dealing with the fact that the court can also get involved in the agreement of the parties. It's determining how you calculate or impute income if a person doesn't provide sufficient records in that regard. It allows the referee to, once they have proof that they have a paternity test of 99%, that they can act on that without having a court make that kind of a decision. Simple things like if the parties agree that documents can be sent by email, and then it also provides a section where once an appeal is made that the documents have to be submitted to the court within 10 days. So it's more of a housekeeping type of thing, and those things make their job a little easier and makes it so that they are more accurate in their determinations.
Any other proponents in the room? Senate Bill 1045.
Thank you, Mr. Chair. Again, Matt Olthoff, Department of Social Services. Just again, wave-topping some of these things. I'd like to draw attention, first of all, to Section 3. This does address the opportunity to go work with the referee more expediently if those situations come up. So that's an easier pathway to what was described by Senator Grove in the previous determination. Sorry.
Little mood lighting.
I feel like I'm on a stage all of a sudden. I do want to emphasize this bill has been amended over on the House side, and I draw a distinction to all of you. The Child Support Commission considered 2 weeks ago before this body, I urged a resistance to Senate Bill 163. This involved how we treat the income tax credit on our federal income tax filing. The House did amend that on the floor, and so that was a wish of Senator Pischke's, and basically the spirit of 163 lives on in 1045 is, I guess, what I'm saying to all of you. And two, there was a discussion that took away from the recommendation of the commission on the over on the House side that had to do with the prior support. So when somebody makes application, there is a look-back mechanism in South Dakota. About 2 decades ago, it was revised down to 3 years look back. The recommendation from the commission was to say, don't do any, just start fresh when the child support proceedings begin. That was omitted out. So we stay at status quo on that for right now, per what the House did to amend the bill. And I just want to draw attention to that distinctions. Despite that, we're not here to resist those amendments. Please don't misunderstand. Just understand that there's a distinction between what the commission's work product was and how it's been amended through legislative process. So again, please hear the people that do this day in and day out, referees, they're the ones that came to the commission and said, these are some streamlining things that would make it easier for all parties, payers, receivers, certainly their work too, and their support of the court system. So sincerely appreciate your favorable consideration to 1045 as amended.
All right, thank you. Any other proponents in the room? Hearing none. Anyone online? Nope. All right, we'll go to opponents, 1045. HB 1045, any opponents? No opponents. All right, we'll skip rebuttal. We'll go to close the public testimony and go to committee questions.
Mr. Chair,
Yes.
I'd like to make a motion.
Wait, I have a question.
Mr. Chair, I would like to make a motion after Senator Grove makes a comment.
I just have a quick question
You bet.
for, I guess, the prime or secretary. I just need to clarify one thing. So in section, in section 2, it says if a parent incarcerated for more than 180 days is released from incarceration, the child support obligation in effect at the time. So that basically is just saying if the person was incarcerated for 180 days and they're released, whatever was in effect before remains, that's the level that they're at.
Mr. Chair, outstanding opportunity. Thank you for the opportunity to clarify, I guess. So what happens today is that there's inconsistency across circuits, and some judges do revert back to the income level prior to incarceration, others do not. This clarifies that, and it is going to set that it'll go to the, on the date of release, it'll go to the minimum wage. Now, there is an opportunity, to your great testimony earlier, Senator, that there was ability to make modifications to that, but basically this is, I think, a realistic examination the commission looked at. It says, you know, what really happens to that individual after a felonious conviction and an incarceration period, their ability to earn a wage is greatly diminished. And so rather than starting in their rears and having a great big backlog right away, the opportunity to say, let's just start consistently across all circuits in South Dakota and then work from there at that minimum wage level.
Good? All right. Senator Blanc, do you have a motion?
Yes, Mr. Chair, I'd like to make a motion of due pass.
I should check. I'm sorry. Any other questions? All right. Do pass by Blanc. Second by Grove. Comments on your motion?
Well, since the secretary has the ability to turn the lights on and off in here, I don't know if that's anything to mess with. Actually, my comment is, when you look at a bill that has this much red ink, sometimes that means red flags, but other times it means that you have taken the time to sit down with multiple parties and work out as many of the issues as possible, and I think that is the case on this bill.
Thank you.
Sure.
Yes.
I was just thinking, we'll make one small comment. I would just like to thank the representative for his amendments on this bill. I think we both got something back into Chapter 25 that we both wanted. So,
Thank you. Yes.
I would say it seems awfully strange that this committee votes against how to treat the income tax credit, and here it is again. But I recognize there's a lot more than just that in this, but it seems awfully strange that we're putting that back in and saying that's okay.
Thank you. Any other comments? Hearing. Secretary, please call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff.
Aye.
Pischke. Hulse, excused. Colbeck.
Aye.
Mr. Chairman, we have 6 ayes, 1 excused.
All right, hearing affirmative vote of members-elect is passed. It does qualify for consent. Does anyone object to consent? If not, please put 1045 on consent. With that, we'll move to HB 1298. Prohibit the electronic publication of certain information about a judicial officer or law enforcement officer and provide a penalty thereof. Proponents, HB 1298.
Thank you, Mr. Chairman. My first time in front of the judiciary. I'm Randy Dibert, District 31 Senate, which is Lawrence County. House Bill 1298 is a product of collaboration with the governor's office to address doxing. What is doxing? It is the malicious publication of personal information about an individual, such as their home address and date of birth, on the internet with malicious intent to strike fear or death or great bodily injury. The typical consequence of such a post can be sending threatening mail or packages, making swatting calls, or staging protests at private homes. This bill establishes the crime of doxing of law enforcement officers and judges. Thank you for your consideration, and I'll defer this to the governor's general counsel. Thank you.
Thank you. Any other proponents? HB 1298.
Hello, good morning, Committee for Senate Judiciary. And Mr. Chair, I am Katie Haruska. I am the Governor's General Counsel. And thank you for considering House Bill 1298 today. And thank you, Senator. I wanted to start with a tiny history, not too far back, from where this bill came from. This bill was mentioned in the Governor's State of the State. He said that he wanted to work with the legislature to deal with this issue of doxing. The initial bill that came forth that was introduced by the governor was House Bill 1083. That received a lot of deep analysis and challenging questions and ultimately was defeated in House Judiciary. But we took all those concerns and considered each, drafted a much more narrow bill. I believe we now have no opposition, and it passed the House with 64 ayes. The biggest difference between this bill and that is that this bill no longer includes legislators and elected officials, which were the primary individuals that caused the concern on the other body. So now this bill is a good, simple bill to help protect law enforcement and judges. So why do we bring this in the first place? What's happening to warrant this bill? Well, across the country and in South Dakota, law enforcement officers and judges are being targeted, threatened, stalked, and doxxed. How we are engaging with each other and engaging with our judicial system is increasing and elevating the degree of dangerous threats and actual assaults against these officers. In October of 2025, one of our federal district judges said that every judge right now is concerned about their safety and the safety of their families, and that the bench is facing, quote, never before seen levels of threats. And this is an attack against the rule of law itself. Sadly, assaults against judges are still happening in their homes, and it continues today. Protecting law enforcement officers and judges from such threats ensures that they can carry out their duties without fear of harm to themselves or families and be neutral arbiters in our justice system. House Bill 1298 is one section. It prevents anyone from electronically publishing a home address, date of birth, social security number, and doing it with the very specific intent to place that individual in fear of death or great bodily harm. So with that, thank you for taking a look at this issue and for your support.
Thank you. Any other proponents? HB 1298.
Good morning, Mr. Chair, members of the committee. Greg Satizon with the Unified Judicial System in support of House Bill 1298. We feel that this is important to ensure the integrity of the judicial decision-making to prevent unwanted and dangerous doxing, the sharing of that personal information about judges, and so would be supportive of the bill and would ask for your support as well. Thank you.
Thank you. Proponents in the room.
Good morning, Chairman, committee members. Stacy Ackerman, Executive Director for the South Dakota Sheriff's Association, and we also rise in support of House Bill 1298. Law enforcement is a dangerous profession, and oftentimes families don't sign up for the same thing the officer did. And we know doxing has happened in the Dakotas. We have a joint partnership with the North Dakota Sheriff's Association, and during the Dakota Access Pipeline, while deputies were hundreds of miles away, families back in their home counties were doxed. We have one deputy who the information, their vacation home and their home got published on the internet, so while he was gone, his wife is seeing all this and home alone afraid. Another deputy, she was sitting in her living room, husband's 100 miles away, gets a phone call saying, "We are gonna kill you unless you get your husband back off the front lines." Families are scared, and we like this bill. We think it's an important protection, and we ask for your support. Thank you.
Thank you. Any other proponents in the room? HB 1298. We're just going to check online. We did have a proponent, but they are not there. So with that, we'll close proponent testimony. Any opponents? House Bill 1298. Any opponents? Seeing none, I thought maybe Mr. Mattson was going to doing a flyby there. I'm like, I thought Katie was maybe going to knock him over the head there for a second. Okay, no opponents. We'll waive rebuttal. We'll go to commission questions. Any commission questions about HB 1298? Yes.
This could be for any of the proponents. I guess I should give the question first and see who wants to send it. Oh, Katie's fine, yeah. Glad you're here, thank you. In line 5, it says, no person may publish by electronic means. What happens if somebody publishes in a newspaper or somebody prints out copies and leaves them on a doorknob or on a windshield? Is that included? Maybe there's other codified law that covers that?
Mr. Chair, thank you. Katie Hruska with the Governor's Office. The current statutes of stalking may cover that. The element of stalking and why this bill is needed is that stalking requires a repeat and a course of conduct. When you publish online, it can take one publication, but that can then be shared and stored forever. And that's where, when things go viral, is sometimes how we say it, and it gets shared multiple times. That's not necessarily meets the element of repeated for stalking. But the instance that you say, when if you print in the newspaper or print something and mail it, I think it would then cover repeated instances of that.
Very good. Thank you. Thank you, Mr. Chair.
Any other questions?
Quick one, Mr.
Senator Grove.
I see that there was a amendment that was tried and must have been on the House floor. I'm wondering why legislators are not included in your bill.
Mr. Chair.
Please.
As introduced, it did include elected officials, legislators, and statewide officials. And in the House Judiciary Committee, there was significant opposition, and ultimately that bill was defeated. And so that's why you don't see 1083 coming across. You see 1298. And so I think there was a lot of concerns that were expressed about how do we get to our policymakers and how do we still voice our opinions to those who make our laws, that we don't want to have the fear of a crime if we do that. I think another instance was individuals may want to prove where residency is for elected officials and be able to challenge that. And if we don't have, if just the publication of their address to petition whether they are a resident of a district, that there was fears that that would have been included in the bill. I don't know that it would have been, but the House floor did attempt an amendment and that failed. And so the bill crossed over in its original form.
Thank you. Any other questions? All right. With that, I'll look for action.
I'd move do pass.
All right, we have a motion do pass. Senator Duhamel, second by Senator Blanc. Comments on your motion?
Thank you, Mr. Chair. Narrow bill with important protections.
Excellent, thank you. All right, with that, we have a do pass motion. Secretary, please call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff.
Aye.
Pischke. Hulse.
Aye.
Colbeck.
Aye.
Mr. Chairman, we have 7 ayes, no nays.
Having received an affirmative vote, members-elect is passed. It does qualify for consent. Any objections for consent? Hearing none, please place 1298 on consent. With that, we'll move, do we want to go back to? Yep. All right, we're going to go back to HB 1040. We have a motion by Melhoff, a second by Duhamel. Do pass. Do we need a new motion? Or are we on the same motion?
Go for it.
Isn't there a rule
The vote
about
was
only having
tied.
one,
Yeah, we gotta-
that motion once per day?
We can take another do pass motion. It's custom that when a member arrives that was gone,
That's
or if
right.
someone wants to make a different motion. But I think
Yes.
we do need another motion because the other one failed.
Yes. So we had this in Senate State Affairs. And as soon as a new member is, all the motions are clean. So we can take another do pass motion.
Mr. Chair, I move to pass.
Okay, we have a do pass motion by Senator Hulse, second by Senator Duhamel. Comments on your motion?
Well, I know I wasn't here for the hearing on this bill, but I was a part of the Child Support Commission, so I feel like I've probably had more information on this bill than probably many people on this committee. And so with that, let's move forward and get this to the floor to have the full discussion of the floor.
All right. Any other comments? Hearing none, we have a do pass motion with a new member in the room, HB 1040. Secretary, please call the roll.
Senator Blanc.
No.
Duhamel.
Aye.
Grove.
No.
Melhoff.
Aye.
Pischke. No. Hulse.
Aye.
Colbeck.
Aye.
Mr. Chairman, we have 4 ayes, 3 nays.
With an affirmative vote of the members present, we'll call it passed. It'll go to the floor. Now we are on HB 1300, accept victims of human trafficking or domestic abuse from certain clemency notice requirements, HB 1300.
All right. Thank you, Mr. Chair and members of the committee. I'm Representative Nicole Uri-Balk, representing District 32 in Rapid City. So House Bill 1300B, as amended, is about safety, common sense, and recognizing the reality of survivors of human trafficking and domestic abuse live with every day. Under current law, an individual applying for clemency must publish notice in a newspaper. While that may sound procedural for someone who has relocated for safety or whose abuser may still be looking for them, that public notice can be real danger. This bill creates a narrow exception to that publication requirement. It does not lower the standards for clemency. It does not bypass the Board of Pardons and Paroles. It simply allows a verified victim of human trafficking or domestic abuse to request an exemption when publishing personal information that would put their safety at risk. So walking briefly through the parts of this bill, it adds a new section to Chapter 2414 with 2 subsections outlining the requirements. Subsection 1 requires the applicant to submit their own affidavit stating that they are a victim of human trafficking, domestic abuse, or a substantially similar crime in another state, and that their safety would be at risk if their personal information were published. Subsection 2 requires affidavits from 2 qualified professionals who may be from the same profession but not the same agency, confirming both the individual's victim status and a good faith belief that publication would create a safety risk. The bill then specifies the categories of professionals who may provide that verification, including law enforcement, prosecutors, healthcare providers, mental health professionals, and victim advocates. This structure protects due process while prioritizing survivor safety. If the clemency process itself creates harm, then the system is failing the very people it should help. House Bill 1300B as amended makes a small but critical correction, and I respectfully ask for your favorable consideration. In both the House Judiciary Committee and the House floor, there was no opposition, and House Bill 1300 received all yes votes.
So I will stand by for questions, but if we could first have Tracy come up for in-person testimony, that'd be great.
Thank you. Further proponent testimony in the room.
Good morning, committee. I'm not Tracy. I am Senator Michaela Boyda from District 21. I'm going to jump in quick. I just want to kind of reiterate that we're not bypassing the Board of Pardons with this bill, and they can still say no if there's a safety concern. The board must still notify and contact victims pursuant to the victims' rights laws. This is not going to be an automatic pardon or freedom, and the board still decides everything, just like normal. And I just urge the committee's support of this. I think it's a great bill. I think there's been a lot of collaboration between all the relevant parties, and I just urge your support. Thank you.
Can we do one online proponent, or do we want to, I know that there's, okay, go ahead, you go ahead.
If you want, we could go to survivor testimony next, that's who's online.
Okay, let's do that first. I think there's AJ? A. Foster, go ahead.
Yeah, okay. Chairman Wheeler and members of the Senate Judiciary Committee, my name is A. Foster, and for reasons I'm testifying under my initials for safety reasons. I am a former South Dakota resident and a graduate from Mount Moody College in Watertown. I am also a survivor of human trafficking, and today I'm here to ask you all to support Bill 1300. South Dakota's clemency publication requirement was written in 1939, at a time that publishing in a newspaper meant local notice. Today, publication is digital, searchable, permanent, and effectively global. For someone like me, that difference is not theoretical. It creates real risk. I have been enrolled in an address confidentiality program since 2018. I have lived in safe houses. I do not maintain a phone or physical address in my name. I have paid to have my information scrubbed from the internet. I've gone to great lengths to remain out of the minds and the sight of the men who participated in my exploitation. Despite that, in December of 2023, a local South Dakota convicted felon located my phone number and admitted to selling my information to my traffickers. That number was the first phone I had placed in my own name in nearly 5 years, and it did not remain safe for even a year. Each time my information is located, I must change phone numbers, email addresses, and sometimes my physical location. That instability affects my employment, my housing, and most importantly, my children's safety. Publishing my identifying information, even in a newspaper, now creates a digital trail that can be indexed, archived, and redistributed. For survivors, publication is no longer a notice, it's exposure. The Board of Pardon and Parole indicated that while they understand my safety concerns, legislative change is required. House Bill 1300 is a narrow and responsible solution. It requires sworn affidavits from qualified professionals from separate agencies confirming that publication would create a safety risk. This amendment does not weaken transparency. It modernizes a pre-digital requirement so survivors are not forced to choose between pursuing clemency and protecting their lives. I want to leave you with this. For most applicants, publication is a procedural step. For me, it is a potential trigger for renewed harm. I respectfully ask you to vote yes on House Bill 1300. Thank you.
Thank you. Yes.
Thank you. My name is Tracy Decker, and I'm testifying on behalf of myself. I'm a resident of Rapid City, and I helped write this bill as a part of my work with the West River Human Trafficking Task Force, where I worked closely with Tess Franzen of Freedom's Journey, which is the human trafficking survivor support organization that A. Foster first contacted to try to get help with this in South Dakota. I've spent most of my career as a prosecutor of sex crimes and domestic violence in Pennington County. So I've made a career out of advocating for victims, but I've also fought for public safety and offender accountability. And that's partially why this bill is important to me, because survivor safety is important, and this bill offers a small measure of safety for survivors of human trafficking and domestic violence who abusers may still be looking for them. And as it's been stated, it does not change the overall process a person goes through to seek clemency. Under the current South Dakota law, the Board of Pardons and Parole still has to notify the state's attorney in the county where the crime was committed, responsible for the prosecution, or the state's attorney that's currently in that office. The sentencing judge has to be notified, the attorney general, and the sheriff or the local law enforcement agency where the offense was committed all have to be notified when somebody's seeking clemency. This in at least 30 days advance of the hearing. Marcy's law and state statutes, as found in SDCL 23A-28C, still require that victims of crime be notified, and the Board of Pardons and Paroles has procedures in place to do this. These victims' rights laws aren't being changed by this, and they have always put the requirement of victim notification on the government entities. It's never been the offender's responsibility. So House Bill 1300B, as amended, does not significantly take away from victim notification requirements. That's indicated in the last portion of the bill so that it is explicit. The BOP is still going to review these applications and make recommendations to the governor, and they make those recommendations in writing, which is transparent, and the governor obviously is not bound to accept those. So this doesn't take any discretion away from the powers that be that are deciding on these clemency issues. It just keeps the circle of people that need to know and must know a little smaller, rather than putting it out into the public sphere, as we've heard a couple of times this morning, that when things go viral, you can't get it back, and it puts these survivors at risk. So this is just one small part of an overall safety plan for survivors looking to move on from a painful chapter in their life and getting rid of an obstacle, a conviction, that may be in the way of leading a productive life in their community if the governor is so inclined to grant that act of mercy. And with that, I urge you to vote yes today. Thank you.
Thank you. Any other proponents in the room? We're at about 8 minutes here.
Good morning, Mr. Chairman, members of the committee. I had a huge, long testimony. I'm not going to say that because everybody else has done a wonderful job. These women just need a second chance, is what they need. And so I'm hoping you will vote yes on this. Thank you.
Thank you.
Just go ahead and have a,
Yep. We got to read shorter pages here.
okay. Do you want me to just hand them out
Yeah,
or give them
just-
to you? Okay.
Yeah, you can. There you go. All right. And you want to just say your name for the record? I can't remember.
I'm Lisa Gennaro with Concerned Women for America and sitting also on the West River Human Trafficking Task Force.
Excellent. Thank you. More proponents, HB 1300.
Good morning, Mr. Chair, members of the committee. My name is Lindsay Ryder-Rapp. I'm a registered lobbyist for the South Dakota Advocacy Network for Women. We also support this legislation. As the proponents have indicated, this is a narrowly tailored bill to provide an opportunity for the victims of both domestic violence as well as human trafficking to start their life anew. We certainly support those efforts and would ask you to as well. Thank you.
Thank you. Proponents.
Good morning, Mr. Chair and committee members. Melissa McCauley, registered lobbyist for the South Dakota Network Against Family Violence and Sexual Assault. I want to first say thank you to both of Senator Voida and Representative Uribulk for being champions for this bill and actually working across all lines to make sure that we've got this very narrowly tailored for 1300. It recognizes that the reality of some victims of trafficking and domestic violence are coerced in criminal behavior and personal harming them. When those survivors later seek clemency, they shouldn't be re-traumatized or placed at risk. This bill is narrow, it applies to verified survivors, and maintains accountability. It simply ensures that the process is trauma-informed and safety-focused. And with that, we ask that you do pass.
Excellent. Thank you. Any other proponents? We're done with proponents online. Any opponents? Opponent testimony, HB 1300. Hearing none, we'll waive rebuttal. Go to committee questions. Any committee questions? HB 1300. If not, just.
I have a quick question.
Yes.
Let's see, how about Ms. Decker? That would be fine. This is a good bill, and big fan of the West River Human Trafficking Task Force. Been a part of it for almost 15 years now, and Freedom's Journey, great program as well. Online, let me go back there. Well, I think it's Let me see if I can find that again. On line 19, since you were part of developing the bill, line 19, it says, believes the individual has a good faith belief. Just to clear things up, what's the burden of proof? What's the burden of proof to meet the definition of a good faith belief?
Sure. Mr. Chair? Thank you, Tracy Decker. That's a good question, Senator, and one that honestly hasn't been asked before. I think, you know, that's one of those lawyer terms, and I'm a lawyer, so sometimes I throw those around without really further defining it. I think when I think of good faith belief, when I'm talking about a professional that's working with somebody, it means that they, in whatever professional capacity they're working, let's say it's a law enforcement officer, or a medical provider, whatever in their professional capacity, they look at this person and say, I have a good faith belief, I believe this person, and I'm willing to put my signature on this affidavit. To me, that's what it means. And if we have to further develop that after this has been in place for a while, we can certainly do that. Thank you for the question.
Thank you. Yeah, I think you should, because it's subjective, and we want to make it as easy as possible for these ladies to not have to jump through more hoops just to protect their lives.
Agree. Thank you.
Thank you.
Thank you. Any other questions? Hearing none, I'll look for some action. House Bill 1300.
Chair.
Yes.
I'd like to make a motion to pass.
All right, we have a motion to pass. Senator Blanc, second by Senator Duhamel. Comments on your motion?
Just briefly, it's common sense. These gals and guys, they've had enough trauma to deal with. They are trying to do their best to escape what crummy situation they've been in before, and we should make it as easy as possible for them to forget what's behind and move on.
Excellent, thank you. Any other comments? All right, we have a motion from Blanc, second from Duhamel, as do pass House Bill 1300. Secretary, please call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff.
Aye.
Pischke. Hulse.
Aye.
Colbeck.
Aye.
Mr. Chairman, we have 7 ayes, no nays.
Thank you. Having received an affirmative vote, HB 1300 is passed. It does qualify for consent. Any objections to a consent calendar? Hearing none, please place that on consent. With that, I am going to hand the gavel over to my vice chair. She's going to run the rest of our calendar, whether it be this morning or this afternoon.
Thank you, Mr. Chair. Now we'll move on to House Bill 1108 to require the sealing of court files upon dismissal or denial of a petition for a protection order. Take proponent testimony. Representative Stevens.
Good morning, Madam Chairman and members of the Judiciary. I bring you House Bill 1108. This bill deals with protection orders, and I've handled a lot of them, and protection orders are very important in our society, and they have some really good reasons to do that, and it's an area that the judges deal with, and so this bill is not intended to have any negative impacts on that there are good reasons for the protection orders. Unfortunately, there are some people who are not using them properly, and there's an abuse that's occurring. And what happens is when a person takes out a petition, then they have to make the allegations that are become public record. And those allegations deal with abuse, harassing, all kinds of things, allegations of molesting children and those type of things. Well, then what happens is, in these instances, a couple of different things that happen. They put those on, they file them, the court then has to set a hearing, and then when the hearing comes, the person doesn't show up, but the allegations are still public record. And so what Section 1 does in this is that if a person doesn't show up, then the court is able to seal that record so that nobody takes that information and uses it on social media. Section 2 provides that if they do have a hearing, but upon a finding of the record that the petition was filed with no basis in fact or law and was in fact harassing, frivolous, or abusive in nature, then the court can do the same thing and heal that and keep that information out. Now, how does those type of things happen? Well, I can give you two really good examples. We have an individual down in southeastern South Dakota that's been filing against county commissioners and other elected officials and other individuals, and the person, they're clearly frivolous. They have no basis in fact or that, and there's some real concerns about that individual's mental situation. But those are public record as it is right now. And so anybody could take those and they could file it against you or whatever and use that and say, well, this person had this petition protection order filed against you. Another one, the most curious protection order I ever had was I had a young fellow come in and an individual had accused him of assault and molesting her children. And as I was talking to this individual and he brought his sister along, she said, you know, this individual made the same accusations against another person. And I said, really? And she said, yeah, she was even on Dr. Phil's show. And I said, you got to be kidding me. And she said, no. I said, well, do you think you could find that episode for me? And about 10 days later, she comes with the episode. So we actually have a hearing, and I started then, when I got to cross-examine her, because she went through the same thing, that he had physically assaulted her, that he had molested her children, and went on and on. So then I started asking the same questions that Dr. Phil did, and I got about 2/3 of the way into Dr. Phil. She took her papers, she threw them on the floor, walked out. And the judge said, well, do you have a motion to make? And I said, yeah, motion to dismiss. And of course, he dismissed it. However, that's still public record. And somebody could get into the public record and use that against people. So the whole purpose of this is to, in those instances where the person doesn't even show up after making the allegations, or if a judge specifically finds on the record that the petition was filed with no basis in fact or law, and also was harassing, frivolous, or abusive in nature, that the court can then seal those records so that nobody can get at them and use them against innocent people. So that's really the purpose of the bill. So I'll stand by for questions.
Thank you. Further proponent testimony on House Bill 1108.
Morning, Madam Chair, members of the committee. Greg Satizon with the Unified Judicial System. I think the prime sponsor did a great job of explaining what's happening here, and certainly feel like this is an area for the legislature to determine as a matter of policy what records should or shouldn't be available. I would just maybe explain kind of how this happens. So when a person seeks that protection order, it goes to the court. It's never served on that other individual unless the court finds that there are sufficient grounds to hold a hearing. And so if the court does make that finding, then it goes to law enforcement to be served on that individual. If the court decides sufficient grounds do not exist, the record is created, it's a public record, but you no longer have a service obligation. And so someone may not know about that. And I would say, while it's not common, it's certainly not infrequent that someone contacts our office or the clerk of courts and says, I just had an employment background check run and there's a protection order that I don't know anything about. Can you help me understand what's going on here? And so the way the current law exists, there's a very real opportunity that there is a protection order that had been sought against you that someone could find if they searched your background and you don't know about it. And so this would allow, in this situation that I just described, that would automatically be sealed, so no one would find it. It would not show up on a record search. The second scenario is the court determines sufficient grounds exist. It goes to a hearing. After full contested hearing, the court determines not legitimate. The party can then move to have it sealed if they're able to make the showing that it was harassing, frivolous, or abusive in nature. So that provides an opportunity for the court to look at the facts and decide if it should be sealed. And the bill also, just to make it very clear, goes back to when it applies retroactively. So as of July 1st, if this should pass, the UJS would go in and seal all those cases that fit that very first scenario that I described. In those other scenarios, a person would have to make the argument to the court and have a specific finding for that to be sealed. But as of July 1, we would go back to 1989 and seal all those records. And so I just wanted to explain that, and I'm sure happy to answer any questions. Thank you.
further proponent testimony?
Good morning, Madam Chair, members of the committee. I'm Steve Siegel. I'm the registered lobbyist for the South Dakota Trial Lawyers Association. We too rise in support of House Bill 1108. We think that fairness dictates this. We think it's good public policy, and we hope you'll support it. Thank you very much.
Thank you. Any further proponent testimony?
Good morning, Melissa McCauley, registered lobbyist for the network. Protection orders in South Dakota are utilized to protect victims, the petitioners, from domestic abuse, threats, and stalking. The majority of protection orders do work to keep victims of violence safe. There have been a few rare situations through that an individual has filed a protection order specifically to cause harm with no basis in fact or law, and the order was abusive in nature. We can support sealing those few protection orders, but we do not want to deflect from the fact that protection orders are beneficial in our state and are overall the majority of the orders provide safety to the victims. And we do appreciate Representative Stevens working with the network on this bill, so thank you. And with that, we ask do pass.
Thank you. Any further proponent testimony in the room? Seeing none, we have any proponent testimony online? Okay, seeing none, we'll move on to opponent testimony. Any opponent testimony in the room? Seeing none, any opponent testimony online? All right, well, with that, we will close the taking of public testimony and move on to committee questions. Any questions from the committee?
Madam Chair.
Go ahead, Senator Grove.
For Sadazon, Mr. Sadazon. Madam Chair. So when you, if this bill were to pass, and you said you went back to 1989, I think you said, would there be some kind, okay, like some people don't even know that they have them, so that would be the one that you would just automatically remove. Would other people be, would there be like a letter informing them that they can have this sealed, or will they be told that there's a possibility about that?
Madam Chair, Senator Grove, so we would, you're correct, 1989, we would automatically seal all those ones that people wouldn't know about. I guess our intention is not to go back and notify anyone just because the numbers would be significant and our addresses would probably be very out of date. I think the passage of the law puts people on notice that this is available if they should find out about one or want to have one sealed.
Any further committee questions?
Madam Chair.
Go ahead, Senator Pischke.
Thank you, Madam Chair. For the prime, if I may. Representative Stevens, Section 2 of your bill I find intriguing. I'm just kind of wondering, obviously we see custody cases in a different viewpoint. That's been long established in this legislature. But in Section 2, there are a lot of times where protection orders come forward to the court in regards to family court. It's typically known as the domestic violence, the silver bullet method. Would Section 2, would this bill, maybe it's not only Section 2, but would that apply, I guess, to those cases as well that you find that, and I'm sure you have found in your years of dealing with family court, that some of these protection orders brought forward are frivolous? Would this also apply in all those situations as well?
Yeah, I believe that it deals with the Section 3 and 4 also and deal with that situation when it comes to custody type of situations. I think you could bring that in and apply to that. Because that's one area that, you and I both know, I mean, you see some really absurd allegations made that are without fact or based upon law, and that applies to that as well. So I think it's across the board.
Okay, thank you.
You bet.
Any further committee questions at all? Seeing none, we'll move on to discussion and/or action from the committee. Discussion and/or action. Senator Duhamel.
I would move do pass.
Second.
So we have a do pass motion from Senator Duhamel, a second from Senator Melhoff. Any discussion on your motion?
I think they made the case, but I think it's important to file those allegations that are harassing, frivolous, or abusive in nature. No fact.
Any further discussion on the motion?
Madam Chair.
Senator Pischke.
Thank you, Madam Chair. Well, I was reviewing this bill last night, and this is the one that actually kind of set my spidey senses off that something might be going on here. But I think I'm going to support this, and And reason being is kind of in my question that I pointed towards Representative Stevens. I've had this exact same thing happen to me personally, and I know you might find that hard to believe, but I've been through this court system and basically had, in my view, a frivolous protection order put against me. And I don't want to get into details because I'll get emotional about it, but I want to thank Judge Salter again, now Supreme Court Justice Salter, for dismissing that. But this would have directly applied to me, and I don't know if it would have been dismissed because we did go through the whole thing, but I think this is a good bill, and so I would support it.
Thank you, Senator Pischke. Don't give anybody any ideas now about protective orders against members of the Senate, right? All right. Well, seeing no other further discussion on this motion, the motion is due pass. Secretary, please call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff.
Aye.
Pischke. Hulse.
Aye.
Colbeck.
Aye.
Madam Chair, we have 7 ayes, no nays.
Having received an affirmative majority of the members elect, the due pass motion passes. We will send 1108 to the floor. Is there any objection not to put that on consent?
I want that talked about.
Okay, we're going to talk about it. So no consent on that one. All right, moving on. We're going to go to House Bill 1183, which is to revise qualifications for immunity from prosecution following a drug-related overdose. Representative Huey.
Good morning, Madam Chair, members of the committee. Just so everybody knows, this is my very last bill pitch, so be kind. Shouldn't be too hard. So back in 2017, some of our colleagues, some of them are actually in the room, passed a bill, and what that bill did was created some Good Samaritan laws related to drug overdosing. Part of that bill was creating immunity from arrest and prosecution for individuals in need of emergency services following a drug overdose, a drug-related overdose. So under that current statute, that immunity only applies if the person experiencing the overdose is the one who contacts law enforcement. And we all know that somebody in the middle of an overdose is probably not going to be the person who contacts law enforcement. So House Bill 1183 simply extends that protection to another person who seeks help on their behalf. This is a Good Samaritan law, and the whole point of Good Samaritan laws is to encourage people to do the right thing. The hope here is really straightforward. It's to save more lives. It's to encourage more people to contact law enforcement and emergency services without hesitation or fear. And we all know that in moments of panic, it can be really difficult to make sound decisions, especially when someone believes that calling for help could actually lead to legal trouble on that person's behalf. I also really want to note that this immunity is not unlimited. So further down in the same chapter, the statute's very clear that this protection may only be used once. This is a one-time immunity designed to prioritize saving a life in an emergency, and it's not going to protect from ongoing accountability. All this bill does is strengthen the safety net. It prioritizes life, it encourages responsible action, and it ensures that the right thing is done in an emergency that could have otherwise been led to a tragic outcome. And with that, I will stand by for any questions. Thank you.
Thank you. Further proponent testimony.
Madam Chair, committee members, Tim Reed, District 7, and I have been involved with this issue actually back when I was the mayor of Brookings. We had students and law enforcement get together and say, we need to do something here. The law enforcement didn't like that if they did come up upon somebody that, in that case it was alcohol, and now we're talking more about drugs, everybody would scatter and there'd be nobody there to help. So everybody was worried about getting in trouble instead of doing the right thing. So I applaud the prime sponsor for bringing this bill. It's a continuation of this journey to make sure that, the Good Samaritans are not punished.
Thank you. Further proponent testimony.
Good morning, Madam Chair, members of the committee. Sam Matson, registered lobbyist for the South Dakota Trial Lawyers Association. We too rise as proponents of House Bill 1183. And I will just echo a lot of the statements previously stated, but this is just a Good Samaritan law. It allows people to do the right thing and not fear of prosecution. to save lives. And we have a drug overdose epidemic in the state right now, and I think this encourages people to, help essentially stop or save a person's life from an overdose. And I think, one death is too many in the state. If we can find a way to save someone's life, that would be a positive. So we would urge your pass on this vote, or on this bill. Thank you.
Further proponent testimony.
Good morning, Madam Chair, members of the committee. My name is Cash Anderson, registered lobbyist for the South Dakota Association of Criminal Defense Lawyers. I'm a lawyer here in town. I echo the sentiments of everyone who came up and testified before me. I think in these scenarios, the number one concern should be on getting that person help and not, am I going to be prosecuted? So I think this is a common sense bill. I think it encourages people to call for help. I think it could certainly save lives, helps people do the right thing, and I think it's good public policy. So ask for a due pass on this.
Further proponent testimony.
Good morning, Mr. Chair, Madam Chair, members of the committee. Roger Tellinghuse, and I'm appearing today on my own behalf. It's hard to get through. My stepson has had a drug problem, a drug history, and his last overdose was in 2022. He was down by Hermosa Fire Station, and thankfully, a friend that was there with him had the courage to call 911. And there happened to be a volunteer fire department, a fireman who is an EMT in the vicinity and responded and administered Narcan. And then the ambulance came and they transported him to Rapid City Regional. And so my wife and I were in the emergency room with him. And the doctor came in and he said, Zach, that's his name, which happens to be my oldest son's name too. So we have two Zachs in our family, but said that Zach was 4 minutes away from death. But for this young man that was with him, calling 911, he would have died. And so I can't think of a better amendment to an existing law than the one that's proposed before you today. And I certainly hope that you'll pass it. Thank you.
Thank you. Further proponent testimony.
Madam Chair, members of the committee, my name is Justin Bell. I'm a registered lobbyist for the South Dakota State Medical Association. That's the prior proponent had much more compelling testimony than I will. I would simply state that State Medical Association supported the original immunity laws when it was going through. We continue to support that. This is really what I would consider to be cleanup legislation. This does not change whether or not the person who makes the phone call in these situations can get prosecuted. That you have to read a statute that's not in this bill to read that. It's the 110. It's the statute before that. This is really just cleaning up what I think no one really thought about when the bill was originally passed, was that if you're the person that calls, can the person that is actually overdosing be immune from suit, or does the person that's actually overdosing need to be the person that makes the phone call? Usually when you're overdosing, you are not the one that's making the phone call in those situations. But we don't want people who are witnesses or friends to be in the situation. Am I calling my friend to 911 and they're going to then get prosecuted or not? I don't think anyone intended that to be the case when that bill was originally passed. And so we would encourage this cleanup legislation to make sure that when lives matter, that we're getting medical help and not worrying about whether or not people are getting convicted or not of crime. So we would strongly encourage that you send this to the floor with a due pass recommendation. Thank you.
Thank you. Further proponent testimony.
Madam Chairman, members of the committee, I rise in
Maynard Konechny, representing the South Dakota EMS Association from Kimball. We rise in support of 1183. We were behind the initial bill that come in. We would rather have somebody alive when we get there with the ambulance rather than on their deathbed and have to call the coroner. We thought when we put this together with the members of the South Dakota Jackrabbits and Larry Tiedemann at that time, that both of those people would be getting immunity, and I think for a while it was, but that's been changed. So we highly recommend that you pass 1183 and move it on for the safety to give those individuals a chance at survival so that when we get there, it's not as bad as what it could be. Thank you very much, and I'd stand by for any questions. Thank you.
Further proponent testimony in the room? Seeing none, I believe that we have one online. So we'll go proponent online.
Thank you and good morning to the committee. My name is Cody Ratterman. I appreciate you allowing me to appear remotely via Zoom. I'm coming before you today as a private citizen. I am an attorney out of Sioux Falls. I'm at Paulson and Ratterman Law Firm. I'm a former senior deputy state's attorney out of Minnehaha County and also a former senior deputy public defender out of Minnehaha County. I brought this bill to Representative Healy out of frustration, as there is a gap currently in the legislative scheme. I think Mr. Bell did an excellent job of describing that situation. I've had 3 cases in the last 2 years that I've taken for immunity dismissals before the court here. We've had expert testimony lay out a foundation that a person who is experiencing an overdose simply cannot call emergency medical services, let alone 911, as they're suffering acute respiratory failure. The common scenario we have in Sioux Falls is somebody takes a drug, they unknowingly ingest a lethal amount, or it's laced with something that they didn't know, such as fentanyl. And in those situations, moments matter. The other scheme, or the other situation that we're facing currently, is this is affecting a population that doesn't necessarily have phones or ways to communicate to emergency services that they're actively overdosing. This legislative fix, basically all it does is eliminate that need for a person to actually call 911 and fixes this gap. I brought this to Representative Healy and I'm extremely appreciative that she brought it forward, and appreciate the support from all the proponents here. Based on a couple clients of mine who are sadly no longer with us, one of those being CJ. And I'm asking this committee to pass this bill, to fix this problem so it stops leading to absurd results that we're seeing right now. Thank you very much, and I'll yield my time for any questions.
Thank you. With that, let's move to opponent testimony. Is there any opponent testimony in the room? Seeing none, I know we don't have any online, so we'll waive rebuttal and move on to committee questions.
I don't know why you always look at me, Madam
Senator
Chair.
Block.
I do have a question, and the question is for Mr. Anderson. Haven't had a chance to talk to Mr. Anderson this session, so welcome and good to see you. Thanks for coming back. I think this is a good bill, and I think it's important. My question is, if the overdose happens during the commission of a crime, burglary, theft, assault, whatever it might be, does that mean that since they are basically going to be held harmless, are they only going to be held harmless for the overdose and ingestion portion, or does that mean that they get carte blanche?
Madam Chair, Cash Anderson, South Dakota Association of Criminal Defense Lawyers. Good question. The immunity would attach to any possession, inhalation, ingestion, taking in the drug. If you committed a murder, burglary, whatever it is, no, you're not getting. That one's sticking.
Thank you very much.
Any further committee questions? Seeing none, we'll move to committee discussion and/or action.
Madam Chair?
Senator Pischke.
I would move due pass on House Bill 1183.
Second.
We have a do pass motion from Senator Pischke, a second from Senator Melhoff. Any discussion on your motion?
Thank you, Madam Chair. Well, I wanted to make the motion, so I got to make comment. First off, I just want to recognize that Justin Bell has been dodging this committee all year, and so I'm glad that he finally showed up to testify in Senate Judiciary. Other than that, I like the bill. I think that it was an oversight when we had this before and missed this, so I think that's a good change, and I think we should pass it to the floor. Thank you, Madam Chair.
Any further discussion?
I'd just like to congratulate Representative Healy on a great pitch. So, going out in style.
All right, seeing no further discussion, the motion is do pass. Those in favor say aye, those opposed say nay, and Secretary will call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff.
Aye.
Pischke. Hulse.
Aye.
Colbeck.
Aye.
Madam Chair, we have 7 ayes, no nays.
All right, after receiving a majority of the members-elect, the do pass motion passes. And House Bill 1183 will go to the floor with a do pass recommendation. Does anyone have any issues with certifying that for consent? No? Okay, we'll put that on the consent calendar. All right, moving right along with House HCR 6015, encouraging the Executive Board of the Legislative Research Council to form an interim legislative committee to study the role and function of county boards of mental illness.
We're going to do that this afternoon.
All right, we're going to do that one this afternoon. We're going to move on to House Bill 1280, which is to increase the penalties for the operation of drones over certain facilities and to provide for mitigation techniques and countermeasures. Representative Jorgensen.
Thank you, Madam Chair and members of the committee. As a prime sponsor and retired military veteran, I appreciate the opportunity to address this important issue. HB 1280 strengthens protections for our prisons, jails, juvenile detention facilities, and military installations by upgrading unauthorized drone operations over these grounds from a Class 1 misdemeanor to a Class 6 felony. And you may wonder why it's being upgraded. Well, drones pose a growing threat. They can be used for unauthorized surveillance, smuggling contraband into correctional facilities, or even endangering public safety at military sites. Current penalties, Class 1 misdemeanor, are simply not deterrent enough in today's environment. HB 1280's felony upgrade isn't about punishment for its own sake. It's about matching penalties to modern threats, deterring bad actors, and better protecting South Dakota's correctional system, military personnel, and communities. A misdemeanor slap on the wrist no longer cuts it when drones can deliver deadly contraband or spy on secure sites with ease. So this bill, what it does is it authorizes the Department of Public Safety to establish rules for approved mitigation techniques and countermeasures in response to federal direction and training for law enforcement, ensuring safe, lawful responses to threats without overreach. This is a focused, common-sense legislation to safeguard our facilities, personnel, and communities. I urge a do pass recommendation and will stand by for questions. Thank you.
Further proponent testimony.
Good morning, Taffy Howard, District 34. Just basically a Me Too. I mean, for me, this is about security, the safety of our, not just the correctional facilities. For me, it's the military facilities. I mean, my husband still works on base. My son is active duty. And I remember when my son decided to go on active duty, it's like, I had to think differently as far as like even Facebook posts. I black out his rank. I black out his last name. My mom was an Army recruiter during the time when recruiting stations were being attacked, firebombed. And so it's always been in the back of my mind. I mean, I never had to face it personally, but this is a serious issue. Drones can carry more and more of a payload. They're more of a danger to our service members, and she mentioned the correctional facilities. So I think this is a critical issue that needs to be addressed, and I would urge a do pass. Thank you.
Further proponent testimony in the room.
Good morning, Madam Chair. Jason Ketterling, Department of Public Safety, Office of Homeland Security. Thank you for the opportunity to testify today. I'm here to respectfully request your support of House Bill 1280 as amended. I also want to thank the prime sponsor for bringing this legislation forward and working alongside us throughout the entire process. The South Dakota Department of Public Safety, the South Dakota Department of Military, and the South Dakota Department of Transportation and the Office of the Governor of South Dakota have been engaged in this issue for some time. Last fall, Governor Larry Roden joined 30 other governors in urging Congress to pass the Safer Skies Act. In December, Congress enacted legislation establishing a federal framework to expand authority of state and local law enforcement to address unlawful drone activity. However, the Safer Skies Act permits mitigation activities only by law enforcement officers who have completed specific federal training. Federal agencies are currently developing the required training standards, operational guidance, and implementing regulations. While that work is underway, it will take additional time to complete. The threat posed by rogue drones is no longer a futuristic idea. It's an immediate public safety concern. Without clear authority and the ability to deploy counter UAS measures, a significant and unacceptable gap remains in our public safety and preparedness framework. For that reason, we requested an amendment to House Bill 1280, granting a rulemaking authority to the Department of Public Safety under Section 50.15.3. This authority would allow the department to promulgate rules identifying appropriate mitigation techniques and countermeasures to address unlawful drone activity over military and correctional facilities. Importantly, this authority would be exercised only after federal guidance is finalized and the required training standards are clearly defined and available. I'd also like to emphasize that rulemaking is transparent. It's a public process. It requires public notice, an opportunity for comment, and a public hearing. In addition, all proposed rules must be reviewed by the legislature's Interim Rules Review Committee before they take effect. This ensures both legislative oversight and meaningful public input. Any rules developed under this authority would be narrowly tailored. They would address only actions that federally trained law enforcement officers may take to mitigate unlawful drone activity in protected areas. They would not regulate lawful drone ownership, registration, or routine public operations. We also recognize that other critical infrastructures in South Dakota may ultimately warrant similar protections. However, until federal guidelines are finalized, it is best to focus on facilities already identified in statute. Once additional federal direction is available, we look forward to continuing to work with the sponsor and the legislature to evaluate whether expanding these protections is appropriate. Finally, House Bill 1280 establishes unauthorized drone use in certain protected areas as a felony offense. That designation is appropriate. Unauthorized drone activity can threaten public safety, interfere with critical infrastructure and emergency operations, and compromise privacy and security. The penalty reflects the significant risks and potential harm involved. Thank you for your time and consideration. I respectfully ask for your support of House Bill 1280.
Thank you. Further proponent testimony. Seeing none in the room, we'll go online. Mr. I'm going to butcher your last name, Nishimura.
Yes, that was great. Thank you, Madam Chair. I'm Tony Nishimura. I'm representing South Dakota Ellsworth Development Authority, and we rise in support of House Bill 1280. I know I only have a couple minutes here, so I will say over the past year, we've been working closely with the South Dakota National Guard, members of the Air Force, local law enforcement, representatives of critical infrastructure, and industry experts regarding the threat that the drones pose to our national security and to the state of South Dakota. Several months ago, I attended a drone symposium up at Camp Grafton in North Dakota. We had a lot of industry experts from throughout the world. One of the most resounding takeaways from this was that we in the United States, especially here in South Dakota, are lagging well behind where we should be in terms of combating and mitigating the drone threat. As was previously stated, with the Safer Skies Act, we're starting to align better. The governor understands this as well. After signing that letter, we see that. House Bill 1280 has amended. It integrates well with the Safer Skies Act. It's an essential step in the right direction for protecting our assets critical to national security here in South Dakota. For that reason, I respectfully request your support of House Bill 1280. Thank you.
Thank you. And then we'll go on to further pro-opponent testimony. Mr. Connell?
I'm Chief Robert Connell with the City of Box Elder Police Department. I currently have jurisdiction, proprietary and concurrent, on Ellsworth Air Force Base and, of course, in the City of Box Elder. Approximately 6 months ago, the Department of Homeland Security put a surveillance device for drones in our area to see the amount of drone activity that we have. And within a 10-day time span, we detected 37 drone flights. So, and we're basically in between Rapid Airport and Ellsworth Air Force Base. So it's critical that we consider the passing of this bill so that it gives us more authority, as previously mentioned by the other proponent speakers. So I appreciate your time, and I ask that you do pass.
Thank you. Seeing no other proponent testimony, we'll move on to opponent testimony in the room. Seeing none, we'll move on to opponent testimony online. Seeing none, we'll close the taking of public testimony and move on to committee questions. Any questions from the committee? Seeing none, oh, okay. Quick draw, Senator Blanc.
Thank you, Madam Chair. Question for the Prime. Thank you, Representative, for being here, and thank you for your service. Just a quick question. In lines 4 and 5 and 11 and 17 and 20, we hear the phrase mitigation techniques and countermeasures. Can you just give us a quick explanation of exactly what we're talking about there?
Madam Chair, thank you for the question.
Just reintroduce yourself for us.
Representative Terry Jorgensen, District 29. Thank you. As far as mitigation, right now, a lot of it is just seeing what they're doing, and there isn't a lot that we can do because until law enforcement has the federal training, they can't do any sort of mitigation as far as jamming or any of that. And shooting a drone out of the sky is actually illegal. So it's right now, this law would place us in the situation where once they have their training, then they could actually start being involved in mitigation according to federal statutes.
Follow-up.
Go ahead, Senator Blanc.
Whenever you see the word countermeasures, the drone is coming down, right? Either through jamming their electronics or shooting it down. So is that something that that we would anticipate doing? Because a lot of these bases are around residential areas very often.
Madam Chair, can I phone a friend and have the Box Elder Police Chief talk about what they can do right now? I will tell you that according to federal statute, they cannot shoot down the drone.
Yeah.
They can't use a firearm. So, but if he's willing if we can I can call a friend. Thank you.
Sure. So, Mr. Connell, would you be happy or be able to answer the question? Essentially, I think the question is what encompasses the definition of countermeasure? How would you handle this situation if this law were to pass?
Thank you, Madam Chair. First, I'm not qualified to speak on behalf of Ellsworth Air Force Base and their activities for mitigation. What I can tell you right now is we work in partnership. We will be contacted by entities on base that there's a drone flight in our area. Then my officers respond to the location of the actual operators. So at this point, our mitigation is contacting the operator of the drone and having them, quote unquote, return the drone to home. And that means that the drone will come back to the operator. At that point, the Air Force Base personnel will take over investigations. Now, moving forward on this, time doesn't really permit us to delay when we receive a drone call in the area because delicate information from the surveillance techniques used could be being submitted to nefarious actors in real time. And so in future mitigation efforts, it would be jamming RFI and DJI signals so that the drone is incapable of collecting any more data. But we cannot do that unless this bill is passed. Does that answer your question?
Yes, Chief. Thank you, and thank you for your service as well.
Yes, sir. Thank you.
Any further questions from the committee? Seeing none, we'll move on to discussion and/or action.
Madam Chair, I'd move do pass.
All right, we have a motion from Senator Melhoff and a second from Senator Duhamel. Discussion on your motion?
Thank you, Madam Chair. Just to maybe provide a little bit more clarity for Senator Blanc's question. When I attended the USS Pier commissioning ceremony, and one of the issues that they had was drones flying near the ship. And a lot of it was probably just curious people, didn't have nefarious, but they actually shot nets and captured the zone. And that was the countermeasures that they used when things got too close to the ship. And I would imagine that would be something that would be reasonable around a correctional facility or other bases. So I think this is a good bill, and I hope everybody supports it.
Any further discussion on the motion for due pass? All right, seeing none, the motion is due pass. Those in favor say aye. Those opposed say nay. Secretary, please call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove.
Aye.
Melhoff.
Aye.
Pischke. Hulse.
Aye.
Kolbeck.
Aye.
Madam Chair, we have 7 ayes, no nays.
After receiving a majority of the members elect, the due pass motion passes, and House Bill, 1280 will go to the floor with a due pass recommendation. Are there any issues with certifying that for consent? All right, let's put it on the consent calendar. Seeing that, we've got 10 minutes left of our time here today, and we still have 3 bills on the agenda. I think at this point, we're going to just do all 3 of those bills this afternoon, if that's okay with everyone. So we'll finish up this afternoon 15 minutes after the Senate adjourns with House HCR 6015, House Bill 1176, and House Bill 1175. But good work today, committee, getting through almost the entire balance of that very lengthy agenda. So we will adjourn, or I'll look for a motion to adjourn. And oh no, I'm sorry, we're going to recess, and then we will come back after the Senate adjourns this afternoon. So, all right, we will be in recess.
As South Dakota's public media network, SDPB serves everyone with transparency, integrity, and commitment to open access. Good, useful, and full of wonder. SDPB.